Miss Denanishia Walton, if you want to appear on Zoom, you're going to need to have your video on and you need to unmute. All right, yeah. I don't know what you're doing with your piercing in your tongue, but we don't need to see that. Want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. So if you want to continue to appear by Zoom, you need to appear appropriately dressed, and nobody wants to see you fiddling with your tongue piercing. All right, you're going to be back on June 2nd. And June 2nd, you can appear by Zoom, but if the court finds that you are not behaving appropriately, Zoom, that will be suspended.
Already say a lot. Walton is fiddling with her tongue piercing, not taking Zoom court seriously, and the judge immediately calls her out. It may look small, but in a courtroom, body language and respect matter. The judge's frustration is obvious, and honestly, if this is how she treats court, it makes you wonder how she treated the vulnerable people in her care.
And then when it gets to be like 60, oh my gosh, it's too cold. All right, so miss, you need to be out of that bed and you're not dressed appropriately for Zoom. All right, you need to put on a jacket or something, miss.
We'll get that.
All right, miss, you need to put on a jacket or something.
And here we see it again. Walton is lying in bed, not dressed appropriately, and the judge has to remind her to change clothes for court. Think about that, she's facing a felony charge, yet shows up like she just rolled out of bed. This isn't just about appearance, it's about attitude. That lack of seriousness sends the wrong message in such a serious case.
Is calling 2024 CR 009527, State versus Denanishia Walton. Could I have parties announced?
Hunter Morris for the state.
Michael Belleville for Miss Walton.
And are you Miss Walton? You need to unmute.
Yes.
All right, Miss Walton, you have a right to appear in person.
It's unmuted. Can you hear me?
Yes. Are you able to hear us?
Yes, I can.
All right, Miss Walton, you have a right to appear in person in court, but I am in receipt of a consent to plea by video conference. Did you review that document with your attorney? Did you understand it and electronically sign it?
Yes.
Did you review the application for deferred adjudication with your attorney? Did you understand it and did you electronically sign it? All right, so you're gonna have to speak up. Nobody can hear you.
I think it's just what I'm on, but yes, yes. You can hear me?
Yes. Did you review the true bill of indictment? You're saying yes?
Yes, I did.
All right, did you review that with your attorney?
Yes.
Did you understand it?
Yes, I did.
Did you understand you're charged with intentionally or knowingly committing bodily injury against a child, elderly, or disabled person at a state facility?
Yes.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
The real weight of the case comes forward. The judge explains the charges: intentionally causing bodily injury to a vulnerable person at a state facility. The punishment could be up to 20 years. But the plea deal on the table? Probation, fines, and restrictions. On the surface, that sounds like a break. But to me, this isn't just about legal consequences, it's about moral responsibility.
Anything you wish to say on behalf of your client?
My client is in Chicago. She understands, she should not have slapped this individual. She does accept responsibility for it. She would just like to move on and be able to work and complete her probation without any problems.
The lawyer admits she slapped a patient. That's not an accident, that's a choice. And when the defense says she just wants to move on, it feels incredibly dismissive. This isn't something you simply move on from. Someone's trust was violated, someone vulnerable was hurt, and that pain doesn't vanish just because she wants a clean slate.
No, I'm working towards getting my CNA.
All right, so this is a situation where somebody just hired you to come in and work in the facility.
I'm a caregiver.
All right, so what's your level of education to be a caregiver?
I finished high school.
All right.
I was-
See, this is what I mean. Everybody's just letting everybody be a caregiver. And the problem is that being a caregiver for somebody, I think that's sort of like a calling. You have to have said, you know what, I'm going into that field because you're dealing with people who have dementia, Alzheimer's, people who can't take care of themselves, people who need somebody to bathe them. The patient gets upset because they're not doing what they're allowed to do anymore. They can't communicate because they have dementia and Alzheimer's. Then everybody and their mothers just hiring random people, paying them minimum wage or less than. And then we end up here with somebody slapping somebody who has dementias and Alzheimer's.
This part is shocking. Walton isn't even a licensed nurse. She only has a high school diploma, hired as a caregiver with little to no training. The judge's anger is justified. These jobs require patience, compassion, and specialized skill. Yet facilities are hiring random people off the street for minimum wage, and the result is exactly what we see here, a caregiver who couldn't handle the responsibility and hurt a patient.
And what was the name of this facility? Let me see. Chapters Living of San Antonio.
The judge identifies the facility, Chapters Living of San Antonio. And suddenly, it's not just about Walton anymore. It's about the institution that hired her. When the name is spoken, accountability shifts outward. Facilities that gamble with patient safety by hiring unqualified staff need to be held to the same standard of responsibility.
All right, court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. There is to be proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with working with minors, no employment with working with people who are disabled. There's to be no practicing as a nurse in Texas or anywhere else. So I'm just going to say no practicing as a nurse. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, 120 hours of community service restitution. The $1,500 fine will be probated. There's to be anger management. I'm ordering anger management because you all agreed to it, but it just appears that you were a person who should never have been working with someone in any type of facility or young children or people who have mental health issues. That's just not a field for you. Good luck to you. Don't take any more of these.
Here comes the sentence. 5 years of deferred adjudication, fines, anger management, community service, and strict bans on working in caregiving or nursing roles. The judge basically says, you're not fit for this field, ever. That's not just a legal sentence, that's a moral one. It's a recognition that some people simply shouldn't be trusted with vulnerable lives. And the judge ends with a powerful truth: this isn't only Walton's fault. It's also the fault of the company that hired her in the first place. That's the bigger issue, a broken system that underpays and undertrains staff.